point before we start. So we will be recording this session as we usually do. So just to let you know that. The topic of employed bar offering pupillages has been something that we've discussed quite a lot, certainly in BACFI and with the BSB as well. More pupillages are absolutely needed, and I think the employed bar has a big role to play potentially in providing and filling some of the gaps in that pupillage market, so to speak. So this is a really timely and important topic for us to discuss, and I know the BSB have done a lot of work behind the scenes to try to clarify some of the bits and pieces around becoming a pupillage provider. So this is quite a timely seminar. So I'm really grateful to the BSB for making the time to come and talk to us today. So I think what I'm going to do is hand over to Victoria, who is going to introduce the topic and give us some insight into why we all feel a bit daunted by the process, or why we think we might not be able to do it, and try and clarify some of those things for us. So over to you, Victoria, and we will have some time for Q&A at the end as well, hopefully. Thank you.
Thank you very much, Gaynor. Can everybody hear me okay and see me? Good. Nobody shouting? Great. It's lovely to be able to speak to you all this evening, and it is a pity we had to move the event online, so we're not getting to meet you in person, but hopefully we can do that another time. I'm Victoria Stetz. I'm Head of Authorisation, so my team handles the whole process for authorising the Authorised Education and Training Organisations, or AETOs, which is the term that we're now using for any organisation that we authorise to deliver either the vocational or the pupillage component of bar training. And here with me this evening is Sophie Madison, Acting Authorisations Manager, and she's going to give you some practical insights into the process for becoming an AETO. Some of you might have spoken to Sam Jensen, the previous Authorisations Manager. She is still with the BSB, but she's now moved into a different role in corporate services, so that's why you haven't got Sam here this evening. Also joining us, although I gather he may be a little bit late, that's Ewan MacLeod. He's Director of Strategy and Policy, and I'm sure he'll join us as soon as his previous meeting finishes. We've also got Julia Whitting, Head of Supervision. And along with Sophie, Julia will be taking you through the bulk of the presentation tonight. And we've also got Laura Gray, a Senior Officer in the Supervision team, who's, along with the rest of us, is here to help answer any of the questions you might have. So we're happy for this to be quite informal. It's not a very big group. So if you do want to ask us to pause to answer a question at any time, that's absolutely fine. And of course, there'll be plenty of time at the end for questions too. And most of all, we really hope that by the end of this, you will be a little bit less daunted and a little bit less mystified by the whole process. And you will feel that we are genuinely interested in listening to what your particular concerns are, because this is a process that isn't a blunt instrument. It's not that we're trying to get the employed bar to fit a process that was meant for other people. This is a process for everyone, and we're keen to understand better how we can help to facilitate the process for the employed bar. So I will now hand over to Julia first of all. Oh, no, I won't. I'm very sorry. I have another slide. I'm so sorry about this. Yes, if you haven't already done so, you can see from the slide what our website looks like. If you haven't already done so, I would encourage you to have a look at the bar training pages of our website. They contain a lot of useful information. You asked us to provide some tailored guidance for the employed bar, and we've created a page that's specifically for such organisations who are thinking of taking on pupils. So that gives a summarised overview of the process that you'll hear more about tonight. And it's supplemented by frequently asked questions, which reflect the questions that we've most often been asked. And we can always add to those at any time if you think there's anything missing. So we hope you'll find all of that helpful, and we will welcome any further feedback that you have. And I will now hand over to Julia. Sorry about that.
That's okay. All right, so I thought first I'd just put into context pupillages at the moment with a few charts and graphs. So I hope you like looking at charts and graphs, because I've got a few here to show you. The first one, it just sort of shows the overall position of pupillages at the moment. So the employed bar is represented by quite a wide range of types of organisations, as I'm sure you're aware. But that's just to remind you, that includes BSB entities, which we authorise to provide legal services. There's other types of regulated bodies in the legal sector, such as firms regulated by the SRA. And then there are non-authorised bodies which have in-house counsel. So we've got commercial companies, financial institutions, and some of you are here today. And we've also got local authorities and government bodies. So all those types of organisations are amongst those already authorised to deliver pupillage. So that provides an interesting variety of opportunities for those seeking to practice as barristers. So the statistics that we've got in front of us are taken from our current records. Just a caveat that we're in the midst of the 2022 peak season for pupillages starting. So the 2022 numbers will, of course, go up over the course of the next few months. But you can see here that there was quite a dip in the total number of pupillages in 2020. And obviously that reflects the impact of COVID. The number of pupillages picked up the following year as start dates were delayed and those pupillages started, and then everybody started to get back to delivering pupillages as normal. But you can see actually the employed bar bucked that trend, and actually the numbers went up in 2020, and that's in particular because the CPS had a bit of a bumper year that year. So the next slide just shows the number of pupillages in chambers. So there are around 220 or so chambers that are offering pupillage, and typically offering 1 to 3 pupillages per chambers. Some offer considerably more, but most are offering a relatively small number of pupillages. And then the next slide shows the number of pupillages in the employed bar. So you can see that typically there are around 18 or 19 employers offering pupillages, and you can see there that the CPS, Crown Prosecution Service, and the Government Legal Service, GLD, are offering a significant proportion of those pupillages. And then the final set of statistics I've got that just puts into context where the employed bar fits into the total picture. So the employed bar makes up about 18% of practicing barristers, but typically offering around 9 or 10% of pupillages. So from that, there is clearly scope for more pupillages to be offered in the employed bar. And as Victoria said, we're keen to encourage that and to support that. So before I hand over to Sophie, who's going to take you through some of the nuts and bolts of the process, to demystify it a little bit, I just wanted to mention apprenticeships, because we have, as part of our bar training reforms, we did approve in principle the apprenticeship route to bar training, but that's not yet available in practice. As some of you will know, because I've had conversations with some of you about this, we have been talking to a number of organisations who are interested in offering an apprenticeship route, and we're starting to get a bit more momentum to that, and we will be coming back to those who've already expressed an interest, bringing people together again towards the end of the year. But if you are interested in the possibility of an apprenticeship route, do get in touch with us. You can email the supervision team on the email on the slide there. And employers often tell us that they're looking to develop paralegal staff in-house, and therefore this is potentially an interesting alternative route for the employed bar, particularly in the larger organisations. But we have had quite a lot of interest from the self-employed bar as well, which is really encouraging. So it is a mixture of interest there. Okay, so I'm going to hand over to Sophie, who's going to talk to you about the actual authorisation process.
Okay, so I'm going to start by talking about the authorisation framework itself and how it's actually structured. So our authorisation framework, which again is available on our website, sets out the criteria that we use for authorising AETOs. And it's set out in 3 principal sections. So we have the components of bar training, the 4 principles of the framework, and then the individual indicators within those principles. So the components of bar trainings, I'm sure you're all already aware, are the academic components, so the law degree or graduate diploma phase, the vocational components, so the more skills-based bar course phase, and then pupillage. So those components sit within approved pathways, which we have considered as part of the authorisation process. We then have the 4 principles of authorisation, and they are flexibility, accessibility, affordability, and the maintaining of high standards. And you will hear those principles referred to throughout the rest of my presentation, so do bear with me. Just to give an example of what we mean by those principles, looking at affordability, I know for many that the cost of bar training can act as a significant barrier, and that does have an impact on the socioeconomic diversity of the bar. Affordability is a broader concept than simply reducing the cost of training. It's also about reducing the level of risk associated with pupils' investment in that bar training itself. So for some, the employed bar may seem like a more attractive alternative to the self-employed bar, where paid employment with associated rights as an employee might seem like a lower risk route to a career at the bar than as a barrister. And the third part, as I said, is the indicators or criteria that we use to authorise AETOs. And we have one of those on the screen at the moment, which I will talk through in a second. So AETOs do need to demonstrate that they've satisfied our principles and meet our standards through telling us how they meet those indicators. So the framework is the same for both the vocational training providers and pupillage providers, but not all of the indicators will apply to both types of training provider. The indicators are categorized as either mandatory or comply or explain. So for the mandatory indicators, you must provide clear evidence of how you will meet them. And in our application guidelines, we set out the matters that you need to explain and examples of the types of evidence that could be provided in support of those indicators. For the indicators which are comply or explain, you need to either comply with one of those indicators or explain why you've considered that it's not relevant to your particular mode of training. And you do need to demonstrate that you've carefully considered how you could still contribute to that relevant principle if you're not able to meet the exact criterion. And your application will be assessed based on the guidance provided under each of the indicators. So this indicator we have at the moment on the screen is within the high standards section of the application. It may look a little daunting at first. There is a lot of detail for each of these indicators, but it is structured to try and give an example of what we are actually looking for. So it is important to say that the authorization process is designed to ensure that organizations are authorized to deliver pupillage by meeting our minimum standards and principles. That also ensures that pupils are confident that when they accept an offer of pupillage, they can expect a consistent standard of training to their peers. Also that the public is protected and that barristers commencing practice do meet our expected standards of competence, and that good progress is being made across the bar in relation to accessibility to bar training and therefore diversity. We don't actually publish sample template policies or other pupillage assessment documents, which is a common question that we have, but our published guidelines document does have tooltips and links to other relevant guidance to support you when preparing your application. So taking this indicator as an example, each of these boxes heads up with the question that you will be asked as an applicant. So in this case, to demonstrate that your training programme adheres to our requirements set out in the curriculum assessment strategy, which is another guidance document on our website. So here the tooltip is a suggestion to you to refer to that curriculum assessment strategy, where the individual competencies of bar training are mapped to each component, and you can highlight those ones that are related to pupillage or work-based learning. We then have guidance, which says that you should demonstrate how your training programme enables the pupils to meet those competencies, and gives a further few bullet points for you to follow when you can use those to structure your answer. And then we also have evidence and support. So that may be an existing policy document that you have. In this case, it's a pupillage training programme. And those can be supporting documents that you upload to support any written answer that you're providing as part of your application. So as Julia and Victoria have already said, the application process is designed to be supportive, and you should have regular engagement with the officer responsible for assessing your application, whoever that is within the authorisations team. And if there is any aspect of the application process that you're finding difficult, you can contact our team either by email or telephone, and we'll be happy to talk you through that. Also, looking at a few of the common questions that are raised by organisations. These are covered in the new FAQs on our website, but just to highlight a couple of these points in particular. Do you need to draft new policy documents before applying? Generally not. This is something that comes up an awful lot. Most organisations are likely to have a suite of policies for their employed staff that can either be given to us exactly or adapted to meet the purposes of pupillage. And that can include things like equality, diversity and inclusion policies, grievance policies, disciplinary policies, flexible working, that kind of thing. And if you're not sure whether your policies would meet our requirements, then again, we will be happy to discuss that with you as part of the assessment process. We may ask you for further information as part of our assessment. It doesn't necessarily mean that if we're doing that you're not going to be authorised. It could be that you're proposing a new type of training programme which contains something innovative or unusual that we need to understand better. So if that's the case, we would seek assurance from you that your organisation had taken appropriate steps to mitigate any risk that we've identified. And in other cases, you may simply have referenced a document in your answer which you haven't actually uploaded in the supporting documents. So in most of those instances, an exchange of emails or a conversation with us is sufficient to resolve any questions that we have. In terms of how long the process can take, it can take up to 3 months, including the time it takes for you to complete the application and then for us to review it and to issue a decision letter. And you shouldn't actually advertise any pupillage vacancies until your authorisation has been confirmed by us. That authorisation is a one-off process. So after that, you will be subject to risk-based supervision by our supervision team. We are unlikely to contact you unless we're doing a particular thematic review, provided that you are still meeting the standards in our framework and you don't come to our attention for any wrong reasons. So the application itself is made through the MyBar portal, which we have on the screen. So barristers, practice staff and some students are already using this portal for a range of different functions. You will need to nominate someone to complete the application on behalf of your organisation, but they don't need to be a barrister themselves. So if the nominated person making the application for you doesn't already have a MyBar account, we can set that up for you. We'll just need to take some contact information and that can be provided to us in authorisations. So the application form will take you through each of the indicators in relation to the 4 principles. And those individual sections can be completed in isolation of each other. So that will allow you to save your answers without completing the whole questionnaire in one go. And you can copy and paste from other applications. So if you have prepared your responses in Word, you can copy and paste them into the online form and then upload any relevant supporting documents. And at that point, I think I'm handing back over to Julia.
Thank you, Sophie. So I'm just going to pick up on a few the areas where we tend to get questions. So next slide, please, Laura. Yeah, so we'll look at pupil supervisors, advertising pupillage and professional statement competencies. So this is where Sophie and I are going to do a bit of a double act. But first of all, looking at pupil supervision. So it's now for the AETO to determine who's suitable to be a pupil supervisor. We used to be very prescriptive about who's eligible to be a supervisor. But as part of the reforms we've made to the bar training rules, we've removed a lot of the restriction, except to say that pupil supervisors would normally be practicing barristers. If you've got others that you want to be involved in pupillage training, then do speak to us. And we're aware that may well be the case in the employed bar, as I say, particularly in the larger organisations. In the self-employed bar, a pupil supervisor can now supervise up to one pupil in their non-practicing period of pupillage and one in their practicing period. That's what we formerly called first and second sixes, which is still common terminology. But in the employed bar, we recognise that other supervision arrangements might be more appropriate, and there's more flexibility for the employed bar. So when you're making your application, you are very welcome to discuss that with the authorisations team. So for example, in the CPS, it's a much bigger organisation. They have different layers of the people sort of at the top of the tree, and others who are involved in a more day-to-day basis for the day-to-day supervision of pupils. So if you have different arrangements in mind because of the way that your organisation is structured, you're very welcome to discuss that as part of the application process. And the pupil supervisors, for the training of pupil supervisors, we've defined some outcomes which are set out in the bar qualification manual. And the bar qualification manual is a really useful document to look at, and it's signposted from the sort of top level guidance that Victoria referred to earlier on our page for the employed bar. But the outcomes that we've set cover 4 areas which are up on the screen there that we expect pupil supervisors to cover as a part of their training process. Many pupil supervisors attend the training that's delivered by the INS. We don't mandate that. So if as an employer you want to devise your own training, that's up to you so long as you meet the outcomes in the bar qualification manual. And I mean, actually, I attend a number of the sessions that the INS deliver, and I always say those sessions are very high level. They can only cover so much in one evening. And, it's for the AETOs to train their pupil supervisors in relation to the training programme, policies and procedures, etc. And, there are wider areas such as giving good feedback, which as employers and potentially line managers, you may well already be having training in those kinds of areas anyway. So I'm going to hand back to Sophie, who's going to talk about advertising.
Thank you, Julia. So all pupillage vacancies must be advertised on the Pupillage Gateway, which you may well have heard of. It's an online portal managed by the Bar Council. There is no fee to advertise on the Gateway, but if you want to use that portal for the administration of your application and other processes, that is subject to a fee, and there are further details about that on the Gateway website. We have relatively recently introduced a mandatory timetable, which runs from November to May each year, which means that all pupillages have to be advertised and recruited within that specified time frame. We did introduce that timetable to improve the transparency of pupillage opportunities, and that's also in support of our aim of increasing diversity in pupillage. In exceptional circumstances, you can apply for a waiver to recruit outside of the timetable, and the application form and related guidelines for that are available on our website. Those applications, again, are processed by the authorisations team. We do sometimes get questions from the employed bar about why it's necessary to advertise pupillage if they have a number of really good paralegals already in-house, or if it's acceptable for roles to be advertised internally first if the organisation requires that. Generally, we would say in response to that, that compliance with the principles of fair recruitment is key to the authorisation process itself, mainly to ensure equality of opportunity for all prospective pupils and to meet the principle of accessibility indicators within our authorisation framework. However, if you do wish to discuss your specific situation with us, then again, we would suggest you get in touch with the authorisations team and we can have a conversation about that. We don't want that to be a barrier to you recruiting pupils. Moving on from that, I'm going to speak briefly about the professional statement and the competencies in that document. So the professional statement, for barristers in the longer form name, describes the knowledge, skills and attributes that all barristers should have on day one of practice. And that's also available for download from our website. As a pupillage provider, you would need to be familiar with it, as all pupils must be assessed in line with the threshold standard and competencies specified in the document. And all ATOs should be using it with their pupils instead of the old style checklist that you may have come into contact with previously. Like the assessment records, we're not providing templates for training records. It is for ATOs to develop their own training plans and records in place of those old checklists. Although they can be used as a model. And you must be able to provide evidence to the BSB if asked that your pupils have met those competencies, that they've successfully completed pupillage, and that they're eligible to apply to us for either a provisional practicing certificate or at the end of their pupillage, a full practicing certificate as a barrister. When there are problems with a pupillage, these types of documents are things that we will want to see, alongside any documentary evidence of how and when pupils have been assessed and how they've received feedback. Most of the time when things go wrong, for example, when pupils complain to us about the standard of training they're receiving, we find that a lack of formality around how pupils are being assessed and how feedback is given to them is a key factor. We have published guidance and case studies on the use of the professional statement as an assessment tool, and that's in Part 4J of the Bar Qualification Manual. Part 4 in general is the part of the manual which relates to pupillage. Another question we get asked is that around pupils who won't be practicing in court when they finish their pupillage, why do they need to meet the same advocacy requirements in the professional statement? Well, the answer to that is that we don't make any distinction about the mode of practice a barrister will be entering upon full qualification. So the professional statement is a universal set of competencies that must be demonstrated in order for a full practicing certificate to be issued. We have discussed this previously with some of the BACFI committee, and someone did make the point that pupillages in the employed bar can be looked down upon by some chambers as being some sort of second-class training offer. It's really important to us that this myth is dispelled, not least because pupils might need the flexibility to move from the employed bar to the self-employed bar at a later stage of their career. And I think at that point, I'm handing back over to Julia.
Yeah, so another question that we sometimes get is around advocacy, the advocacy competence. So what happens if pupils don't have the opportunity to practice oral advocacy during their pupillage? And I mean, actually, that's a question that applies not just to the employed bar, but parts of the self-employed bar as well, where pupils aren't necessarily going into court in the second part of their pupillage. I mean, what we would say is it's your responsibility to design a programme which enables pupils to meet the competencies, all the competencies, as Sophie's just said. But if it's not possible to do that within your own organisation, then something to consider is a secondment arrangement. And that's also, there's some more information on that in the Bar Qualification Manual. That's Part 4J. So the employed bar and the self-employed bar actually can gain mutual benefit from secondment arrangements, because pupils out on secondment obviously are benefiting from a wider range of work experience than the ATO might be able to offer. But it also helps to build some beneficial commercial or other working arrangements between organisations. So the CPS and the Government Legal Service regularly engage in secondment arrangements with chambers. So there are things to think about, and as part of the authorisation process, we'd look at what secondment arrangements you might be proposing, and we've set out some typical areas of risk that you might want to consider, and we'd expect you to think about those when devising those sort of arrangements. So typically that's likely to be around the possible conflicts of interest arising from casework. So we'd expect there to be clear policy and documentation that address specific obvious risks or perceived risks where there's the potential for conflicts of interest. So for example, with a HMRC pupils being seconded out to chambers, there's obviously potential source of conflict of interest for chambers that are working for or against HMRC in cases. So for longer secondments, we'd normally expect both organisations to be authorised as ATOs and to agree in advance how the training and the appraisal of competence are going to be managed during the secondment. So we'd expect the lead ATO to have copies of training and appraisal documents so that they can sign off the pupillage, and the organisation offering the secondment would be having to keep training records and communicate that back to the original ATO. But with shorter secondment arrangements, that it may not be necessary for the organisation to be an ATO. So again, as Sophie said, if you've got something in mind, do talk to the authorisations team about it as you go through the authorisation process. So I think that's all from me and Sophie. So just hand back to Victoria to wrap up.
Thank you both very much. It's been very helpful to set out all that detail, hopefully. As we've said, please do look at our website at all of the tailored guidance that is there for the employed bar. And I think we've already mentioned the Bar Qualification Manual a number of times. That's another source of information that I think you'd find very useful. And it sets out all the requirements for pupillage. We also encourage informal discussions with prospective pupillage providers. If you're not quite sure whether you want to go through this whole process, we're very happy to have an individual conversation with you. So if that's something you're interested in, then please contact the authorisations team. And both the authorisations team and the supervision team, both teams are there for you to help after you've been authorised, should any issues arise or if you want any ongoing conversations. So we hope you found that helpful and useful, and we're very happy to take any questions.
Thank you so much, Victoria, Julia and Sophie. That's been super helpful and really interesting. And I think for me, you touched on a number of points, obviously. So I'm from a commercial organisation, and I know a couple of other people on the line are too. And it's very kind of close to our in terms of how can we move things forward from a commercial organisation perspective. And I think some of the things you've touched on are kind of drawn out. For example, even just kind of completing a relatively complex application process. It's not just like in chambers, it's just all the barristers will do it, all the clerks will get involved, or the admin people. In a commercial organisation, you've got to pull in HR, and you've got to pull in the compliance team, and you've got to pull in the policy team, and trying to get everyone on the same page and over the line to do that can be a significant lift in and of itself, and quite an investment of time. So the easier the process can be, the better. I think that's easier to sell internally, and that's really what it's all about in a commercial organisation, is selling to the organisation why it would work best for them. and what it can bring and what the advantages and why should they invest in that. So I think that's really good. And then I think another couple of points that I really get concerned about is the timetable point. You know, when a budget comes out, you've got limited time, got the budget, you need to spend it, and then you lose it if you don't do it within a certain time. So that the timetable point is something that's quite interesting. And what goes with that is the advertising as well, which I know one of our requirements is we have to advertise internally for fairness reasons. So it's, you know, that you've touched on a lot of those points, but I can see that people have already got their hand up to jump in and ask questions. So I'm sorry, I was so busy wittering, I didn't know who put their hand up first. So Ian or David, I don't know who wants to go first.
Ian was first after you.
I was just wondering whether there was a minimum requirement for salary to be paid to a pupil, because I know the Law Society does, doesn't it, for trainee solicitors? I just wondered if there was any particular criteria on that.
Yeah, so our handbook rules on this subject fall in the equality and diversity section, which applies to BSB entities and chambers. So for chambers in particular, because they're not employers, they're not subject to the minimum wage requirements as employers are. And we have set the pupillage funding rate, we now set it annually with regard to the living wage foundation rates, which is slightly above the minimum wage rates that the government sets. So we usually announce that in November each year for the following January, and then it applies for that calendar year. Actually, we announced that a bit early this year because of all the turmoil in the economy at the moment. The Living Wage Foundation announced their rates earlier than usual. As I say, as employers anyway, you're subject to minimum wage requirements, but you know, we would hope that you would be paying the Living Wage Foundation rates as a minimum.
Right, thank you.
David, did you want to go ahead?
Yes, I did. Firstly, thank you for a really great talk. One of the main obstacles to providing employed pupillage, I think, is getting to grips with the rules. They are quite daunting and complex and often located in different places. So having you walk through them now on this talk is really helpful, and the new materials you're putting on the BSB website is really helpful to signpost people through what is quite a labyrinth. So thank you for that. I was hoping to take the chance to ask you about requirements for advocacy experience. You did touch on this earlier. It's quite difficult for us in-house to know where the goalposts really are in terms of what is enough advocacy experience and what is a good enough quality of advocacy experience. We may have litigation departments who are very busy with litigation day in, day out, but they're not sending people to court necessarily. Do you think it is possible to satisfy the requirements in-house, or do you think a secondment to a chambers would always be required to meet those litigation requirements?
Shall I attempt that one? Others feel free to jump in.
I'll go after you, Julia.
Yeah, I mean, I think, I suppose the message we've been trying to get across here is that, you know, it's not a one size fits all application process. So we will have these discussions with you, you know, as you go through the application process. So if you've got concerns that you might not meet the criteria or you're doubtful about it, then just speak to the authorisations team. You know, they'll help you through that. I think the secondments, I think, where they can be arranged can be really helpful in getting advocacy experience where that's not available in-house. And I think, as I say, organisations on both sides of the secondment, the giving and the receiving end of the secondment, both seem to benefit from what people tell us. So I think they can be useful arrangements, and I think there are all sorts of other short-term secondment arrangements going on in other chambers anyway, just to broaden people's experience. So you know, for example, I've heard that pupils in the self-employed sector doing media work being seconded out for short-term to media outlets to, you know, sort of, you know, see the day-to-day workings of the organisations that they might then subsequently be working with. So I don't think there's a kind of yes or no type of answer to that. I think if you've got concerns about it, then talk to authorisations. Sophie, did you?
Sure. And just to follow on from that, I've seen a lot of these applications now, and predominantly from the self-employed bar, but we do have some in that mode of practice who don't have the same in-court advocacy. Those who are working in Chancery, for example, are very unlikely to have that kind of in-court advocacy for pupils, and will frequently design a sort of an in-house advocacy training program for their pupils. So they'll be conducting certain exercises, they'll have short assessed pieces of work, they may be, you know, carrying out an exercise that is then assessed by members of a pupillage committee or the head of pupillage. So we can see that as a variation on the traditional in-court advocacy experience. And we've certainly approved organisations who have offered us that kind of advocacy experience as part of their application. So it is, you know, the authorisation framework and those indicators are there. But as I said, for the lot of them where they are comply or explain indicators, we're genuinely interested in seeing how you would like to, or how you would try to meet those indicators. So there may be things that we haven't considered before, and that will then encourage us when we're having conversations with other organisations of, well, have you considered this? We've seen this working in other types of organisations before. So as Julia says, we're more than happy to have those kind of conversations with you, because it may be that we've come across something in another application or in a conversation with another provider that could be useful to you in making your own application.
Thanks.
Michaela, I think you have your hand up.
I do. Thank you, Gaynor. Before I move on to my question, just on the point of advocacy, and following on from David's point, I wonder whether there is scope for the employed bar to actually look at secondment within solicitor practices as well as chambers, working with solicitor advocates. I appreciate that they won't necessarily be regulated by the BSB, but it is still a regulated environment, and I wonder whether that could actually be an additional solution for the employed bar to help with the advocacy experience.
I think that's a great point. And again, I mean, I think what I'm taking away is it's a bit more flexible than we probably otherwise thought it was in terms of come and talk to the authorisation team, if in doubt. So perhaps that's one thing the authorisation team could have a think about, Michaela. That's definitely a good suggestion, because I think a lot of us from the commercial side would probably need to go down some kind of secondment or partnership route to get that advocacy. I mean, David and I are probably in the same position, and Ian, in terms of being able to provide that. Our whole raison d'etre is to not have the company in court. So we, you know, that would be a bad thing if we were. But obviously there's a lot of different types of advocacy structures that we can provide, but not court advocacy. I think that's the one thing that would be missing.
Yes, and to Michaela's point, sorry, Michaela, I was just going to say, I don't think it's, to my knowledge, it's not a situation that we have considered before as part of a previous application, but there is no reason why we couldn't have that conversation. As you say, it's a type of advocacy experience. It is with a regulated legal professional. And we would look at obviously the level of the advocacy, whether it is someone who's operating at the county court level, or if it's a solicitor advocate, as you say, with those higher rights of audience that is more likely to be directly comparable. So it's certainly something that we would consider, even if it's not one that we have looked at so far.
Thank you, Sophie. I just thought it's purely a numbers game. There are actually more solicitors' practices than chambers, which may work. So, okay. So to my point, it was actually really addressing something that Sophie had covered and Gaynor alluded to, which is the mandatory timetable. I'm in the unique position of sort of being interested in pupillage from chambers' point of view as well as from the employed bar. And I fully accept and understand the reasons behind the introduction of the mandatory timetable. Having said that, I do think it creates barriers both for chambers and the employed bar. And I know that when it was introduced with an undertaking to review it in November 2022. So I wondered what the position was on that review, how that review would be undertaken, and whether there was a consultation process.
I take that. Yeah, I mean, all aspects of our training reforms are subject to an evaluation process, and that is definitely one of them that we will be picking up on as part of our evaluation. So that's in our planning at the moment. I'm not sure that it will be November, but it's certainly coming up soon, as far as I'm aware. I don't know if Ewan wants to say something more on that.
Not really, no, just that it is something we're imminently looking at. We're looking at the whole operation of the gateway and how that's been working over the last couple of years. So watch this space, I think, is probably the answer there.
Okay, thank you both. Do you think there will be a consultation as part of the assessment?
The Bar Council have recently had a consultation out about the timetable. So they've collected some evidence. I haven't seen the outcome of that at the moment, but I mean the way we've conducted the evaluation so far, we've tended to send out questionnaires, we've had focus groups, so we've had a sort of combination of approaches. But I mean, from my perspective, I want to reach out to as many people as possible to get feedback. So I wouldn't necessarily say it's a formal consultation, but there will be a process of evaluating it, which will reach out to all the stakeholders.
Lovely, thank you, Julia.
And Lisa, you've been waiting very patiently.
Hi, first of all, thank you for arranging this session. I just want to ask about retention. So what is the model to, I suppose, get a return on investment? So you're investing in the pupil, doing the 12 months, and what's to stop them then just sort of crossing over and going into self-employed practice, given the lack of or the low number of pupillages that are offered at the independent bar?
Shall I take that one? I mean, in principle, there's nothing to stop them. I think from what I see, the majority of pupillages now are offered with a review to retaining somebody at the end. I think there's a bit more movement in the criminal bar, where people tend to move on to so-called third sixes. So, you know, a probationary period of tenancy. But I mean, something we encourage is when pupillage is being advertised that you know, it's clear. And it's now part of the authorisation framework. You know, it's clear what the opportunities are at the end of pupillage in terms of being taken on as a tenant or as an employee of the organisation. And you know, that's a real selling point. You know, if you're saying to a pupil who's looking at a range of applications that, you know, there is a potential job at the end of this for you. We're recruiting to invest in you and retain you. That's a big selling point. It's got to be a big selling point. And, you know, I think there's a lot of, as I said at the beginning, there's a lot that's attractive about the employed bar in terms of, you know, offering, well, there's not much certainty in the economy at the moment, it's true, but, you know, the opportunities to progress within an organisation, where there's a bit more of a clearer career path ahead, is a potential selling point. So, you know, you will be asked as part of the authorisation process what your information you're providing to prospective pupils about what they can expect at the end of their pupillage. So I think that's really for organisations to sell. There's no kind of there's nothing to stop people moving on, but there's everything to attract them to stay.
Yeah, so if I can just add on to that, we've certainly seen more in applications, again, from the self-employed bar, who are being very upfront in their advertising and in their applications to us, that they will only advertise for pupils when they have the real prospect of actually bringing them in as tenants immediately. So if they feel that there aren't those vacancies for tenants there, they will have a fallow year. And so that's very clear in their advertising. And that is something that we're starting to see more. Similarly, we are starting to see it being built into pupillage policies and training programs, that there is a presumption that the pupil will be remaining. So rather than them having to make an application to remain, whether that's as a tenant or as an employee, that they will automatically be considered for that unless they sort of verbally or in writing opt out of it. So we are starting to see that more, where the actual presumption is when they are signing up to that pupillage to begin with, that they are signing up with the intention to remain until they actually say, no, actually, I want to go somewhere else. So again, as Julia says, there is nothing we can really do to prevent them from making that move, but it is something that we're starting to see more of. Even at the beginning of the process, organisations and chambers being keen to make sure that this is not something that is just done to get them out the door. This is something that's being done as a means of development for the organisational chambers, and as a means for them to expand.
Okay, thank you.
So I think I see another hand up. Is that Michael?
Yes, hi. Thank you very much for having me this evening. I'm not a member of BACFI, so I've snuck in anyway. I work for a relatively small solicitors firm, which in theory is quite keen to offer pupillage. That I think the one sticking block that we have for persuading the management to allow us to apply is essentially the advertising point. At the moment, our trainees solicitors are all recruited from our paralegals, and our website actually sort of says we recruit internally. If you'd like to apply for a trainee contract, apply for a paralegal role, and so it's sort of set out there. So I suppose my question is in relation to the advertising requirements. I got in front of me that there's an application for a waiver. And I can see it essentially it says exceptional circumstances. It lists that internally recruiting isn't exceptional, but then says unless the pupil is subject to an open competition, and essentially the role, at least when they come into the company, is open, and it flags that this is an option. So I suppose first of all, what would be considered an exceptional circumstance? Second, essentially, if we advertise in the way we do for our trainees, so if it's clear that when you apply as a paralegal, one of the development opportunities is a pupillage, would that be something that would satisfy the authorisation team? And then finally, the waiver approach, is it something that has to be done annually, or would that be something that's considered once when we apply, and then that would be sort of remain in force?
Okay, shall I start with that one? And others can jump in if they want to. So there's a few points there. Taking sort of your last point first, applications are usually done on a one-off basis because they are for individual pupils that people are intending to take on. We have granted longer-term waivers in the past for particular circumstances where we've had longer conversations about their recruitment practices with organisations, and have granted something a little bit more long-term. So that would be a case-by-case discussion. In terms of the exceptional circumstance, it is it is sort of purposely vague to an extent, because we cannot predict exactly what circumstances our prospective pupils will be coming to us with. It's really just to put the onus on the organisation to justify why such a waiver should be justified for that person, that it's not simply a means of circumventing the normal requirements. It's actually there is something particular about that pupil, whether it's because they are coming from another field and they would bring a particular type of expertise to that organisation by getting them in as a pupil and getting them qualified, or something else, whether they are being sponsored by another organisation to complete their pupillage. So there may be something specific about that pupil themselves that would lead us to consider a waiver. Having said that, we are open-minded in looking at these applications. We will consider all the circumstances. It's not a binary yes or no process. It's much more nuanced than that. And in terms of the internal recruitment point, that section of the guidelines is really looking at the kind of recruitment process that those individuals will have gone through in coming to your organisation in the first place. So have they gone through any kind of competitive process that would be in any way akin to the pupillage recruitment process? If they are being brought in at what we would consider to be a lower level, can we really say it's fair to consider that equivalent to pupillage competition, which can be very strict, very oversubscribed, and often quite high level in the terms of, the types of questions that are being asked, but also the sort of assessments which might form part of a pupillage recruitment round. And this is part of that standard process. So can we see that there is something equivalent that has happened there? If we can see that, and that may be my means of providing your selection criteria, giving some indication of what your overall recruitment process is, if it's multiple rounds, if there are assessments as opposed to just interviews, then we would look at that as part of the waiver process to be considered. Again, case by case, we wouldn't be able to guarantee the outcome in advance, but it's something that we would be willing to have a conversation with you about. But I don't know if anyone else wants to come in on that point.
Great. Does that answer your question, Michael? Or yeah?
Yes, it does. Thank you very much.
Okay, perfect. So I'm not seeing, I'm just having a quick look down. I don't think I see any other hands up. So on that basis, I think I'm going, oh, no, Michaela. Yeah, just sneaked in time.
Sorry, rather than a question, it was actually a tip to anyone who is doing the application. As part of a process I was involved in, Sophie provided me very kindly with a numbered working document for the questions on the application form, and I found that incredibly valuable as part of the discussions and going backwards and forwards. So a tip, if you are going through that, reach out to Sophie, because she's got a wonderful document that will help the administration of your process.
Sure, thank you, Michaela. And I think what we're talking about there is that the application form is split into sections. So, for example, for flexibility, you might have flexibility question 1 or question 2. Each of the individual questions within the application form also have a question number attached to them that just goes from 1 till the end of the questions. So there can be some confusion if we're trying to get in touch with you and saying we're talking about question 17, actually which question 17 do we mean? So we do have a document which sets out all of the questions with their section numbers, and that's something I can provide to you on email very easily. The other thing I was going to say, because we had a comment earlier about putting the application together, the guidance document on the website, the first option that you will come to if you're looking for guidance for putting these applications together, where I was talking about the indicators and those tooltips, and we gave a little example of that in the presentation before. You can work through that entire guidance document preparing your answers. It's a Microsoft Word document, so you can share it internally if it does need to go to different departments again, as someone else was saying earlier. So if you want to prepare your entire application offline using that Word document, you can. it can then be passed to one central person who's responsible for putting it onto the website, and they can sit there and copy and paste the relevant bits into our online form with any other things that they need to upload as supporting documents as part of that. So it doesn't necessarily need to be something where everybody is huddled around a screen looking at the same online form. It can be worked through offline using that Word document, and I know a lot of other applicants that I've talked to have used that and have found that a helpful way of putting their application together before then moving to the online form.
Great. So I still don't see any other hands up. Shoot them up now quickly before we... No? Okay. Thank you again. We really, really appreciate the time. I think this has been super helpful, and you can tell from the questions, I think, that we're really keen to be able to fill some of these gaps in the pupillage market. So I think a good outcome of this might be that you get flooded with questions, Julia and Sophie. I don't
Definitely.
know. I apologise in advance, but I think you've got the answers to most of them anyway. So thank you again. Yeah, I'm sure we'll talk again about this. Thank you. Just to reiterate what David said, thank you again for putting the guidance together. We'll still work through it, and if there's anything that we find that might be able to be further refined or is particularly important for the employed bar to offer these pupillages, then we'll obviously be back in touch for some further discussions. But that's been super helpful. So I think just before everyone goes, thank you everyone for joining. Just a quick plug that we've got our next event in 19th of October, I think it is. It's a student evening, so please, if you can make it, come to that. And then the bigger event is the Denning Lecture, which is on the 7th of December at the Athenaeum. So grab your tickets early, because we've got the great Sarah Lawson KC, who's going to speak that night and give the Denning Lecture. So we're super excited about that. Thank you all again, and it's time for a glass of wine or dinner. So thank you so much for joining. Thanks again, everyone from the BSB. Appreciate it. Thank you.
Thank you.
Thank you.
Bye-bye.
Bye.
Bye-bye.
Bye.
Bye-bye.
Thank you. Bye.